The following while court is in session. There's no eating, sleeping, slouching, laying down, walking, smoking, eating, drinking, or driving. If you're operating a motor vehicle, when we call your case, we will need you to pull over to a safe location. Have your vehicle engaged in park before we can start your case, because you cannot operate a motor vehicle and be on Zoom at the same time. That is for your safety. Also, all parties are to remain, again, please keep your devices on mute until your case is called. Also, all proper courtroom protocol and demeanor is in place, meaning all parties must be fully and completely and properly attired for court. This is case number 233-43844. Parties on. Lucy Odera versus Marie Bennett. Odera party, if you're in the room, please unmute your camera, give your first last name.
Judge, I'm here. Kevin Hammonds for Marie Bennett.
All right, thank you. Do we have plaintiff's counsel? Is there a, do
no,
we have a
he's
plaintiff's
in
counsel?
and he's on the screen.
All right, thank you. Odera party, please state your name.
Musa Odera.
Okay, thank you. And Mr. Hammonds, your appearance, sir?
Judge Kevin Hammonds, P46497.
Okay, thank you. Stand by. Court is in receipt of certain documents. Court's going to review them. Stand by. We're going to pass on this matter. All parties, please place your devices on mute. Please stand by. We're going to call some other matters, and then we'll circle back around on this matter. Thank you, sir. Ladies and gentlemen, all parties, keep your devices on mute until your case is called. We're going into hearing. This is a recall on 233-43844. Parties on.
Your Honor.
You say Odera versus Marie Bennett and Javion Butler Hill. The occupants, parties at 13511 Wisconsin. Mr. Odera, thank you for your patience, sir. If you can unmute, start your camera, give us your first last name again, sir.
Musa Odera.
Thank you, sir. And Marie Bennett, do we have an attorney on the Bennett party, Ms. Blaney?
You do. That is me, Judge, and you have my
Thank you,
in front of you.
Your appearance, sir.
Kevin Hammonds, P46497, for Miss Bennett. And
right,
I think that's her with the big blue initial, white letters, blue background. There she
Hi,
is.
Ms. Bennett. Unmute your device. Give us your first last name, please. Ms. Bennett.
Marie Bennett.
Okay, thank you. I'll take your address, please. Ms. Bennett, state your address, please. Did we lose her?
No, she's there.
511 Wisconsin Street, Detroit, Michigan, 48238.
Okay, thank you very much. All parties stand by, please. The court is in receipt of pleadings, and the court thanks everyone, all the parties in advance for providing those. Stand by. All right, and thank you, everyone. The court had an opportunity to review the pleadings, including Mr. Hammonds' answer to the complaint, demand for reply to answer from the defenses and proof of service. In addition to that, the court is in receipt of what are incident reports filed with the Detroit Police Department from the plaintiff. A particular note in relation to compared with the notes that the court made to the court's file is that originally this case came to this particular court on April 4, at which time issues regarding warranty deed as well as lease became an issue, as well as the court requiring all parties to exchange documents. So we adjourned it to today's date for an evidentiary hearing. The court also required any and all communications between the parties, as well as any documentation, including police reports that the plaintiff alleged that he had, and the court does appreciate that the parties have followed through on that. To that point, the court is simply making observations to the record in no particular order. The court, in addition to reviewing the defendant's answer and affirmative defenses, the court is also reviewing at least one or two incident reports to Detroit Police filed by the plaintiff. Of note is that the date that these incidents were reported to Detroit Police to generate an incident report was April 11, 2023, which coincides or is shortly after, well, basically the same day as April 11, 2023. We were in session that morning when the court indicated that all parties must submit to the court, as well as exchange between the parties, any documentation, including police reports. And of note is that it wasn't until April 11, shortly, which would have been the same day that we were in court, that the plaintiff actually went to the police department and made a report with regard to incidents that happened allegedly back on January 31 of 2023. So it wasn't until the court articulated, presumably on the record on April 11, the existence of any police reports, if they exist, to provide those. So it suggests that the plaintiff went to the police department and filed a police report reflecting past events, but did not do that shortly after the alleged dates of the incidents, one of which was back approximately on January 31, 2023, as well as any missing items that the plaintiff alleged and damages to the property on January 9 of 2023. These reports were not made until the day the court indicated that all parties were meant to submit discovery to the court, as well as between the parties. So the court does make that as a matter of record. Further, the court is in receipt of the defendant's, on behalf of her attorney, the answer to the complaint, demand for reply from the defenses, and proof of service. A particular note to the court is paragraph 5 under affirmative defenses with regard to the allegation of, rather, an assertion of the anti-lockout statute with regard to change of locks without providing the tenant with keys. So let's start there. Mr. Hammonds, to your knowledge, is there a particular date or time frame by which this issue with regard to the change of the locks occurred?
My client is available and she can testify to that, Judge. About, I guess, 3 or 4 weeks ago, I visited the premises as part of my due diligence, and I saw the, the typical security door that Detroiters have on their homes with the bars. And I saw it, that particular side door enters into my client's kitchen. So it's an important part of ingress and egress. And she advised me that she was never given keys to that. And that could be a fire hazard, Judge, if they have to vacate the house and the front door is not available. So I've known of it at least 4 weeks, Judge, and it has been that way since my client moved into the house. Judge,
okay, stand by.
Has made that request. What my client advised me was that the plaintiff said, you may change the locks and pay for it and give me keys. And Judge, that's a reverse of the circumstances that should take place.
Okay, stand by. Mr. Adira, and we appreciate your patience, sir. We were working in this matter along with another of other matters that have since been scheduled on our docket. Let's circle around to the issue about the keys and we'll start there, okay? Okay. Sir, did you change the locks? I mean, let me ask you this, sir. What were the condition of those locks at the time that the tenant took possession of the property or moved into the property, sir?
They were aware that that door does not lead directly to their kitchen. It actually leads to the hallway, the shared hallway between the two tenants. And they were aware that I did not have those keys to that side door. And they were made aware of the keys. We wrote down on the lease how many keys were given to them. And they were aware that I didn't have those keys. And the tenants failed to pay me the entire security deposit. And they, when I asked them, could they pay the rest of the security deposit, they began to ask me about that door over there. And I told them that when you moved in, I told you I didn't have that key. And I told them that if you pay me the rest of your security deposit, I can use that towards replacing that security door to where I can have a key and I can give you guys a key. And basically that's when we led up to all the issues of them not paying the security deposit. They stopped paying rent. They started damaging the property, throwing out my stove, my couch, my refrigerator. Like I said, they haven't paid rent. They haven't paid their full security deposit for me to be able to do any repairs, and they were aware of that door.
May I respond, Judge?
Hang on. We started with the issue of the keys. So Mr. Adira, again, we appreciate that, but let's just stick with the issue of the keys, okay? We're not going to get into anything else.
Okay,
You indicated, so you're saying you do not have a key either to that door?
no, and it does not lead to directly
Okay,
to their
then-
kitchen.
Okay, well, let me ask you this, sir. Does anyone, to your knowledge, have a key to that door, this particular
No.
court door that's at issue?
No. The
May I
tenant who lives
respond,
upstairs for
Judge?
30 years.
Mr.
doesn't
Hammonds,
have-
please. Mr. Adira, again, what were you saying about the key?
I was saying even the lady who has been living there for 30 years doesn't have the key to that shared door of the hallway.
Okay, Mr. Adira, that's kind of a concern. You're saying you own the property, so why not basically make that door accessible? That would be your responsibility.
Yes, like I said, I can make it accessible. Right now, I do not have any fundament due to me not getting paid the security deposit or February, March, April, and they're not paying May either. So, like I said, I don't have the funding, and I can barely even pay the water bill that they're
Okay,
accumulating.
Mr. Adira. Okay,
Mhm.
Mr. Adira, let me ask you this, sir. Have you changed, okay, aside from that particular lock, that particular door,
Never.
did you
No, have
change
not.
any locks? Please listen, aside from that particular door, we've already addressed it. Did you change any other locks as it relates to the property that this tenant, to her apartment, to her unit?
Never have, Your Honor.
All right,
Instead,
thank you.
they have been locking out the upstairs tenant from being able to get into her unit. But no, I have not changed any locks.
All right, thank you. Now, okay, here's the thing. We're not going to be able to get into every single thing because we have other cases that we need to get on the record. The court simply wants answers to its questions, so please stand by.
May I respond, Judge?
Briefly, sir.
Judge, I would point out one of the responsibilities of serving as a landlord is to keep the home safe for the tenants that reside there. As an officer of the court who has visited the premises, I will state, Judge, that that particular side door enters into the kitchen. You open the door, if it could be open, you go up 3 steps, and then you go into the Miss Bennett's kitchen. So that is important to her. But to the degree that it is shared, Judge, that's also a safety and a fire hazard for the upstairs tenant. Judge, so I would say, I would hope the court does not minimize the fact that this side door is not accessible for safety reasons and as a fire hazard.
Okay, noted. Here's the thing, but counsel, as to paragraph 5, it suggested that your client, that the plaintiff added locks and didn't provide that key. And when the court asked about that, you indicated this particular door, and Mr. Adira is indicating that the door has been locked and that no one has access to the key. So it's not a matter of him denying the tenant access to the key. Now, the court is not suggesting that any of this is perfect, but that does not suggest that Mr. Adira took a proactive stance toward preventing your client from accessing the property. The way you submitted your pleading made it suggest that he changed the lock.
Judge,
And there's nothing to suggest that that's what happened.
Judge, let me be clear. The court is misreading the statute. That particular door has to be accessible for egress and ingress. Whether he didn't change the lock or the lock has always been there, it's a fire hazard, it's a safety hazard, it's a violation of the statute. And because my client doesn't have access to that door, she doesn't have access to the entirety of the premises that she rented. That's a constructive eviction. So, Judge,
Okay, well, Mr.
I would ask,
Hammonds
but simply, Judge, I would ask the court
Mr. Hammonds,
not to
order.
minimize
Mr.
the
Hammonds,
issue.
order.
I'm
Mr.
sorry, Judge?
Hammonds, order. Mr. Hammonds also understands, sir,
And Judge,
that
I'm
also
asking the
suggests,
court to
Mr.
allow me to
Hammonds,
make a record.
that also suggests, Mr. Hammonds, that also suggests that at the time, based on Mr. Adira's representations, that at the time that they had a discussion about that key, she accepted those conditions. There was not a
That's
key at the
something that
time.
cannot be accepted. You cannot accept a fire
No.
hazard or a safety issue. And I would point out that what the court is doing in advocating this particular point of view, the court is prosecuting the landlord's complaint.
Counsel, the court is not
landlord.
advocating, this court is not advocating anything, counsel. The court is simply going through the pleadings as well as what is before it at this time to render a decision one way or another. There's an opportunity for the parties to be heard on this matter, and the court asked about item number 5, and you responded and you've made your record, and we thank you, sir. But
And
we do
I
need to
thank the
keep moving
court for
forward.
allowing me.
Next.
Well, Judge, why don't you go to paragraph 6, which says that there are no smoke alarms or smoke detectors in the flat. I
There is.
cited the case that the anti-lockout statute addresses smoke alarms and smoke detectors, 600.2918, subparagraph 2, subparagraphs small f. Judge, that's something that the court can address as well. And again, this is something that I have seen. I'm not giving testimony. I'm simply stating as an officer of the court that I know whereof I speak. And
Your Honor, I have lived in that unit myself, and I know there's smoke alarms in there right in the bedroom. It actually went off on me before. Unless they have physically removed the smoke alarms, then there's smoke alarms in there unless they've removed them, because I lived in there.
They haven't removed them.
Smoke
All
alarm
right, gentlemen, order. This is not a free-for-all. Nobody say a word, not another thing. We're going to pass on this matter briefly. All right. Recall on 233-43844. This is as to parties on Musi Adira versus Marie Bennett. Again, the court appreciates your time. We're working in resolution of our other matters throughout the day with this particular case. And as the court indicated, the parties have made their representations, and the court has also rendered to the record its observations with regard to what was presented to this court by way of pleadings and filings and communication, including the investigation report. Of note that raises a concern is that these reports appear to be in response to the court's request for any documentation. Of note is documentation and as well as correspondence appear to be in the form of text messages between it appears to be an occupant of the premises.
Judge, if it's an occupant of the premises, that would be hearsay. Someone has to sponsor those text messages.
Noted, counsel.
Thank you.
The court is not reading it into the record. The court is simply making a note of its observations of items submitted to the court for the court's review.
Thank you.
And Ms. Bennett, we appreciate your patience, ma'am. If you can just start your camera so we can see you on screen. Hi, ma'am. We're gonna please raise your right hand. Do you swear affirm testify about to give will be the truth?
Yes.
You have the right.
Oh, I'm sorry.
You have the right. There you go. Do you swear affirm testimony about to give will be the truth?
Yes.
Okay. Your name, please.
Marie Bennett.
Okay. And ma'am, you still reside at 13511 Wisconsin, correct?
Yes.
Okay. And just to clarify, ma'am, you did in fact sign a lease agreement, to your recollection. Is that correct?
Yes.
Okay. And you've had an opportunity to hear the representations of your attorney and then also the plaintiff. And just to clarify, ma'am, have you been paying rent? Just to clarify.
So
Objection, Your Honor. This is a TOT case. Ms. Bennett, please be quiet. Judge, this is a TOT case. Rent has nothing to do with it.
Okay.
And the court knows I'm right in that respect.
Yep.
And Ms. Bennett, is there anything that you wish to add regarding these proceedings?
Yes, I would just like to add the fact that when I moved in, I mean, I have 3 younger children, so I moved in kind of on a desperate kind of spin a little bit, you can say. I kind of used what the opportunity that was in front of me as far as him presenting the property and the things that it detailed. I did tell him that we were going to need access to the side door because we don't have separate doors to our units. So we have to interfere with our tenant that lives above us, and we didn't want to interfere with her. So we did let him know that we were going to need access. And his exact words were that if we get the locks changed, that we will have to pay for it, and that he will need access to it. He will need the keys as well. He will need a key copy.
Yep. So do.
And I
All right,
didn't
stand by.
coming from a landlord.
Okay, and just to clarify, ma'am, have you removed any items or fixtures or items from the property?
Yes, with his permission, is actually written in our lease. And he's actually told us verbally that we can remove anything that he left behind. Just let him know ahead of time. The refrigerator did not work. It was molded, and as well as the stove did not work. I cook for my family, so I needed both appliances functioning, and they neither one of them were properly functioning. So I told him that I was in the process of removing those to get functioning appliances for my unit.
Okay, all right. Okay, so when you move, and the court appreciates the circumstances under which you moved into the property, but it was with the understanding that there was an issue about access to that door. Again, not for any particular reason, but you were aware at the time, correct? And you and he had discussion about it?
Yes.
Okay, all right, thank
Judge,
you.
I'm going to object to the court's inquiry because, as I stated on the previous record, there cannot be a waiver of health, safety, and fire issues such as the smoke detectors, or in this instance, access to the outside from one of only 2 doors in the premises. I think to the degree that the court makes a record of that, you're misreading the constructive eviction and the anti-lockout statute.
And counsel, the court did not ask those questions for that purpose. The court simply
Oh,
wants
I'm
some
sorry.
clarification.
I appreciate the court clarifying the record. Thank you.
Okay, give an old magistrate the benefit of the doubt, okay?
Judge, I have tremendous respect for you and for your knowledge of the law, but I just try to make a record day by day as we go.
Okay, and Mr. Adair, we thank you for your patience, sir. We appreciate that, and you've complied with what the court has asked you to do. In short, sir, why is it that you're seeking to regain possession of the property, sir? In short.
Basically, like I said, Davon has threatened me, ran to my car and tried to attack me. He has threw away my couch. He has threw away my stove, my refrigerator, without letting me know anything, without giving me the opportunity to pick them up. They were all working appliances. The side door does not go directly into their unit. They have their own separate doors. And upon moving in, I told them that I did not have that key, and they did not ask for that key. They have not paid rent since February, March, April, and now going on May. And like I said, the things she stated under oath were incorrect, and they were actually lies. I never said that, told them to change the lock
Mr. Adair,
and give me the key.
Okay, Mr. Adair, you're doing great, but here's the thing, sir. We're not going to characterize anyone's testimony, okay? So it's not for you to weigh or say that's a lie. Just respond to what your understanding is at the time, okay? Mm-hmm. So we're going to leave it at that, okay?
Okay, and there was also complaints from neighbors of them verbally threatening them.
Move the strike, Your Honor, when he's talking
Mr.
about
noted.
Of neighbors.
Noted, Mr. Hammond, sustained. Mr. Adair, here's the thing, sir. You cannot repeat what other people said to you, okay? Because those people are not present, okay? You can only give testimony or present any information to this court about what you personally heard or saw. Do you understand? Not what anybody told you. Do you understand?
And there were police reports based on that I turned in.
Move the strike, Judge.
Okay, again, Mr. Hammond, sustained. Here's the thing, sir, okay? The court asked him in short to describe what he's looking for in terms of termination of tenancy, okay? We're not delving into all these other details. Mr. Adair, again, here's the thing, sir. You need to stick with what the court asked you, and the court appreciates that the question was probably broad, so forgive me, okay? So let's define it a bit more, okay?
Okay. The damage done to the windows, the damage done to the screen door, the removal of my fire alarms if they're not there anymore. Just those are the things.
Judge, that's speculation on his part.
Again, Mr. Hammonds, please stand by. Mr. Adair, here's the thing, sir. You don't have the benefit of having an attorney with you, okay? So we understand that you're simply giving your account and the attorney is responding to what we refer to as court rules as far as what comes into evidence and what does not, okay? So here's the thing. As it relates to any, please listen, as it relates to any damage or alleged damage to the property, we need to separate that out. Okay, the court appreciates that's part of why you filed for termination of tenancy. But if there are any issues with regard to damages to the property, that can all be dealt with in a separate issue about anything that you've lost, that you allege you've lost, or anything that that you believe is missing can be dealt with in a separate civil action. Okay, so we need to carve that out and set that aside for now. Okay. Okay.
The threats made to me as well. Their police
Okay.
support.
And that. All right. Thank you, sir. So stand by.
While the court's reviewing the documents, I'd point out to the court Affirmative Defense 1, which is a violation of Security Deposit Act. It says that it's part of Truth in Renting and the Landlord-Tenant Relations Act. But what the act says is that the landlord can only accept 1 1/2 times the monthly rent as a quote unquote security deposit. What this landlord did is that the monthly rent is $850. He charged a first and last rent, which would be $1,700, plus a $500 holding fee, which is designed, according to my client, to prevent the landlord from showing the apartment to other parties. So if you look at those three figures, 2 months rent plus a holding fee, that is well more than a 1 1/2 times the monthly rent. So the most that he could expect from the client is
Okay, gentlemen, order. Mr. Adair, here's the thing, sir. Procedurally, there are certain things that we have to do in court. You cannot interrupt another party when they're speaking, okay? Because as a practical matter, the court can't hear two people talk at the same time, okay? Secondly, no one's going to this court would not let anyone interrupt you, okay? So you need to extend that same thing to all parties on this case, okay? You cannot interrupt. That is not prohibited. That is not acceptable, okay? So if you have something to say, hang on to that thought and you will have an opportunity to respond, but you cannot jump in and interrupt anyone, okay?
Thank you, Judge.
He's making his please stand by. We're not done. So, Mr. Adair, please understand, if anything comes up in testimony, hang on to that thought and you will have an opportunity to be heard. Do you understand? Okay. Also, the attorney is going to make representations in response to whatever's coming up, okay? So he's going to make his responses. So please hang on to that thought and you'll have an opportunity to respond as well. Okay? The other thing is, as a practical matter, in addition to all of us talking amongst one another, there's another person in the room, Madam Court Reporter. She has to make a record of every single thing that we're saying. So literally everything we say, she is recording. If two people are talking at the same time, we cannot get a clear record. Do you understand, Mr. Adair? That's the reason why we do this. Do you understand? Yes or no?
Yes, I understand.
Very good. So please stand by. Okay, gentlemen, that's the reason why the court just said order and everybody needs to stop talking, okay? Because whenever that happens, it's going to stop. The court will stop it, okay? So that doesn't make it okay to jump in and interrupt anybody else, because the court will address that with anyone where that happens. If two people are talking at the same time, the court's going to stop. And if we need to take a break so everybody can get a breather and gather themselves, we'll do that, okay? Because every time we have to stop and have a discussion just about how to conduct ourselves in court, that slows us down. We can't get to the facts of the case. So the court's hope is that this is the last time we need to discuss this. And everybody here is reasonable and understands how the protocol goes in court. Okay, so please stand by.
Judge, to finish my thought, the most that Mr. Deere could demand of my clients moving in would be $1,225, which is 1 1/2 times the monthly rent of $850. So he's violated that statute. I also point out in Affirmative Defense 4 that he's constructively evicted my clients by not allowing her or her boyfriend to use the basement in the subject property, which is an integral part of the premises that she is leasing. And that again is also a violation of the anti-lockout statute, and the particular citation is in Affirmative Defense 4. And I point out, Judge, an additional safety hazard in Affirmative Defense 9. The bathroom tub is peeling. My client is concerned that the peeling paint may be lead-based. Okay, and despite her request, he has not come out and done a lead test for the paint, for the peeling paint on the bathroom tub. And
Okay,
I would
Mr.
also point out this, I'm sorry, Judge?
Mr. Hammonds, one thing, and I appreciate your recitation. You're hitting the highlights of your pleading. But counsel, the court is looking at page 5 of the residential lease agreement signed off by your client, particularly as it relates to subsection AA, where it says breach of lease and right to re-enter and regain possession if tenant fails to pay rent or violates any of the terms of this lease.
You can't bring in a rental issue and a termination of tenancy action. Judge, you made a record of that in a hearing earlier today. The court well knows that, and to the degree that the court itself introduces non-payment of rent in a termination of tenancy action, I say it and I say it again. The trial court is prosecuting the landlord's complaint for possession. You're piercing
Counsel, the court is asking questions. The court is simply asking questions to get to the heart of the issue.
May I finish my thought?
Counsel, briefly.
You are violating the Michigan Code of Ethics, particularly Judicial Canon number 3, subparagraph A, capital A, subparagraph 12. You cannot pierce the veil of judicial impartiality. And in this instance, you're doing it by making excuses for the plaintiff's failure to follow statutes and court rules, and doing so, contributing to that record. Thank you.
Okay, counsel, and the court appreciates you making your record, but be advised and let the record reflect that this court is going to inquire because, one, we've got a plaintiff here who is unrepresented, and the court appreciates your advocacy on behalf of your client. The court is simply trying to get to the heart of certain issues in relation to your pleading, sir, and to extract and to get information from Mr. Adira to basically get to the heart of the issues in response to your pleading, sir. The court is not taking sides in any of these matters, or simply this is an evidentiary hearing, and this is an opportunity for the matter to get the issues out on the record. So please stand by. Mr. Adira, what is it that you wish to say, sir?
I'd like to state that I did, in reference to what the attorney was saying, that I charged too much for a security deposit. I charged them for the first month's rent, which is $850. I charged them for the last month's rent, which is $850. And I charged them $500 for a security deposit. $500 for a security deposit. They only paid $250. So $500 is very legal for $850 rent to be charged for a security deposit. And secondly, when he stated that I refused to give them access to the basement is clearly a shared space, and I never denied access for them to share the basement with the upstairs lady. And after that, you mentioned that there was chipping paint on the bathtub. I was never aware of this. The bathroom tub that was not chipped when I rented them that, and it was never mentioned to me until today. And like I have stated before, if this was mentioned to me while they were complying with the lease term, then I would have gladly repaired that, as I've already repaired things in the house, as well as things that they have broke on purpose. And
move to strike, Judge. That's simply speculation on his part.
Okay, Mr. Hammond, sustained. Mr. Dara, please stand by. Here's the thing, sir. You can't add to your testimony or anything that you represent about what they intended to do, because you do not know that. Okay, you cannot add that as part of your testimony. Okay, if it turns out that you were not aware, that's fine. Just state so, but you cannot speculate or provide or make any statements about what you think was on the person's mind when something allegedly happened, okay? So that being said, okay, that particular remark is stricken from the record. Next, Mr. Adira, why not? Because this is a this is a lease that's actually still active until July 23rd. Why not file this as an action for non-payment of rent?
Because I was aware that this was I could file a termination of tenancy by a lawyer. They told me that I could give them that. That's why I did that, so that was the effective way to do an eviction in Detroit. That's what I was told.
Okay, well, Mr. Adair, please be advised, sir, that the lease that was signed here is from July 13 of 2022 and is still valid until July 13 of 2023. And in the absence of stating a reason why you're terminating the tenancy, that raises an issue about how it was. No, sir, it needs to be as a part of your, hang on.
Yeah, on the summons, I put on there damage to the property, threats, and I can read up what else is put on there. And I've sent in police reports and all evidence of those things.
Move to strike the police report reference, Judge, as hearsay. And with respect to what he's placed on the summons, Judge, the summons is not the place where you put allegations that lead to
that was on the complaint. The complaint.
Okay, gentlemen, here we go again. Tell you what, we're going to pass on this because we indicated before we can't talk over one another. We're going to pass on this briefly.
That's fine, Judge. And when you do recall the case, my client has her hand up, and I would ask that she be allowed to address the court.
Okay, so noted. We're going to pass on this. Attorney Zarin. All right, as to case number 233-43844. Again, this is a recall on Musi Adera versus Marie Bennett. Here's what we're going to do because we are going to go short on time. Ms. Bennett, what is it that you want to say or respond to, ma'am? Just unmute your device. Mr. Adera, please stand by. We're going to go one at a time. Stand by, Mr. Adera. Please calm down. Both parties are going to have an opportunity to be heard. Please. Ms. Bennett, what is it that you want to say, ma'am?
I just wanted to speak to the fact that as a landlord, he has not been by to assess the property since we moved in. That's about 8 months now. And anytime we did bring up an issue to him that we wanted him to take care of because we felt like that was his responsibility, he basically just sends out the threats of wanting to evict us and trying to rush us to get out of the property because we're having problems or we're complaining about the property. We've paid rent up until this whole thing started, honestly, Judge. And we stopped because we felt untrustworthy of continuing to give him money, and he's continuing trying to push us out of the property for unlegitimate reasons. There's no property damage that we've purposely done. And anything that we have has been fixed to the best of our ability, and he has been aware of. So I just wanted to put that on the record that any communication has been done up until this eviction and termination process has started.
Okay, Mr. Deere, what did you want to say, sir? Unmute your device, sir.
Your Honor, I'd like to state that the reason for the eviction stays the same on the complaint to recover the possession. It was due to threats made by Javon Butler Hill to me on January 31st and damage done to the windows as stated previously, and damages done to the screen door that were done as stated and sent pictures over, and disrupting the upstairs tenant, etc., as stated.
Move to strike, Your Honor. When he talks about disrupting the upstairs.
Party, stand by, Mr. Adair. Hang on. There's no objection. Mr. Adair. Stand by, Mr. Hammonds.
Thank you. When the landlord talks about my clients interfering with or obstructing the upstairs tenant, this is pure A, speculation, and B, hearsay. That would have to be something that the upstairs tenant would have to be brought in, sworn, and would testify herself. The way that he's presenting it, it's just simply a statement off the top of his head. I could simply say that Mr.
Well, Mr.
doesn't
Hammond,
like
okay,
me.
Mr. Hammonds, again, we don't know where it's coming from. Objection
So,
sustained. Mr.
thank you,
Adara,
Judge.
sustained.
Can I finish? What I was-
Mr. Go ahead, Mr. Okay, hang on, Mr. Adara. Here's the thing, sir. Here's what we're going to do. Mr. Adara, was it else that you want to add?
I wanted to finish what I was saying. I stated that the reason for the eviction is the same exact thing I put on number 5 on the complaint to recover the possession of property. It's due to threats and damage done to the property. At the time of the threats and damage to the property, there was no rent owed except for the $250 deposit. That's why I did not file a complaint of non-payment of rent. I have done all repairs to the property that were needed before January 31st. When that was the day where the threats were made as listed in the complaint to recover possession, and that's when the damages were all discovered. And that is the reason why I'm evicting the tenants, due to the threats and the damage done to the property.
Okay. Mr. Hammonds, last thing, and then we're going to wrap it up. But we're going to do this decision in writing. What is it that you want to say, sir? Mr. Hammonds,
Judge,
anything further, or do you wish to ask Ms. Bennett any questions?
Judge,
Do you wish to ask Ms. Bennett any questions, sir?
my client, no, I don't need to voir dire my client, but I do need to state for this record, it cannot be that easy, Judge, for someone to say that another person has threatened them or caused them harm without bringing anything in the way of evidence for the record. He does not have any witnesses. He has not stated any injuries or how these purported threats have changed his life or caused him in any way, shape, or form damage of any sort, Judge. It is pure speculation on his part based upon the record as it exists now. And I think the court should not
Let me state one more thing.
Okay, gentlemen, order. Mr. Adira, again, I am not going to, okay, here's the thing. We're toward the end of the day. There's not much new that's going to need to be added. Otherwise, it's going to be a back and forth between the parties. Mr. Adira, you had an opportunity to speak. And again, Mr. Adira, please understand the attorney is making representations is not meant to provoke a response from you, okay? This is what attorneys do all day, okay? They make their representations and then the other side gets an opportunity to respond, but it's not an opportunity to jump in and say, no, you're wrong, okay? You have got to exercise impulse control, Mr. Adira. You got to. That's the way it works, okay? That's what attorneys do. Thank you. Mr. Hammonds, 2 minutes and we're going to wind
30
down.
seconds, Judge. All I'm
Very
saying
good.
about the issue with respect to the purported threats is that Mr. Adair has to make an evidentiary record. He has not done so thus far. And so for those reasons, I don't think that the court can consider these allegations of threats, Judge. So that is really it. I have cited my affirmative defenses. They are based upon statute and court rule. And also, the last thing I wish to say, Judge, is the defendant's demand for reply to her answer to complaint pursuant to 2.110B, that's capital B 5. Judge, he hasn't filed an answer he hasn't filed a reply to my client's answer. I understand he is improper, but he is still obligated to follow the court rules as if he were an attorney. It is his choice that he choose not to retain counsel, and it is his choice to come into an environment where learned counsel and a learned judge practice daily. He chose to come in the manner that he chose to, and so he cannot be held or absolved from responding in the way that an attorney would. So in your reply, I should say in your findings of fact and conclusions of law, I wish you to address the failure to file a reply to my client's answer. Thank you, Judge.
All right, thank you, Mr. Adair. Last thing, was it that you want to say, sir?
Due to those threats that I have reported in the complaint, as well as in the police report, I do not feel safe going to my own property. I do not feel safe around this gentleman. So, I mean, I feel very threatened by the words and the actions he has stated. I had video recording of right before he ran down to my car and decided to threaten me in the way he did. And yes, Your Honor, I do not feel safe. And I like I said, the reason for this complaint as written down were the threats and the damage done to the property, and I do not feel safe, Your Honor.
All right, thank you, gentlemen. We appreciate your time on this. The court will render its decision. At this time, we are concluded. All parties can disconnect.
Your Honor, has my case have been concluded yet?
Yes, sir. That's what we indicated. We closed our proofs on that, and we are all set. So the court will render its decision in writing. Thank you, sir. Good luck. You can disconnect.
So what is
Thank you for asking.
So what is going
Count-
to be done?
Sir, the court is going to render its decision in writing. We are concluded at this time, sir.
So I'll be getting mail, or?
That is correct, Mr. Adair.
I've been in an eviction process before in this courtroom, and I've never
Mr.
heard of
Adair,
that.
I understand, Mr. Adair, but the court, there was an evidentiary hearing. It was not as simple as simply making a decision because we took testimony. Court is going to review all of the documentation submitted by the parties. The court will render its decision in a writing, in an order, okay? So that's a
when
separate
should
issue because we had, Mr. Adair, please stand by. The court will render its decision. It's not going to be, just please stand by. You will receive something in the mail. We thank you. We are
Within how
concluded,
long?
sir.
Within how long?
Mr. Adair, again, the court needs an opportunity to review all of the pleadings and all the documentation submitted. The court took an opportunity today to put more get more information based on what was submitted. So the court will render its decision, sir. The court is not going to set a timeline, but the court will render its decision. So please, we will render a decision. Thank you.